Hello, and welcome to Victim Rights Act, everything a Deputy District Attorney should know regarding the Victim Rights Act. My name is Kim Branham. I am the Victim Rights Act Specialist with the Division of Criminal Justice for the Office for Victims Programs. Let's start off with a little history of the Victim Rights Amendment. In 1982, President Reagan had assassination attempt made upon his life, and at that time he realized that he did not have any rights as a victim. Now, being the president, he probably had more rights than you or I, if we had gone through that during that time. But what the president did is the president established a task force and asked for that task force to go out and speak to all victims of crime, ask them what they liked about the criminal justice system, ask them what they didn't like about the criminal justice system, and ask that this task force come back and report to the president. When the task force went out and spoke with victims of crime, they determined that our nation was a national disgrace on how victims were treated and that something needed to change. So President Reagan started out and started with the constitutional amendment, and currently we have 37 states that have one that are afforded to victims. Colorado's passed in November 3rd of 1992 and went into effect on January 14th of 1993. Our Colorado Constitution talks about three very important things. It talks about how victims want to be heard when relevant, informed, and present during all critical stages of the criminal justice process. These three words, heard, informed, and present, were all three things that victims had reported to that task force that they were not receiving. So they asked for these to be changed. In our legislative declaration that we have, I always like to read this last section where it says that all victims of and witnesses to crimes are honored and protected by law enforcement agencies, prosecutors, and judges in a manner no less vigorous than the protection afforded to criminal defendants. I think this is very forward thinking because I'd like to see that at some point our victims will be treated better than our defendants, but I don't necessarily think that is happening today. So I think we're very forward thinking and knowing that at some point we could get to that point. Our core victim rights are based on treating victims with fairness, respect, and dignity. This is one of our top complaints that we get here in the Division of Criminal Justice regarding Victim Rights Act complaints. It is also one of the hardest to prove. Okay? Treating a victim with fairness, respect, and dignity could mean a wide range of things. One of an example that I can give you is for the district attorney's office is we've had complaints come across where a victim feels that they were treated poorly by the district attorney because meeting in a consultation with them, the district attorney was talking way too fast, felt rushed, felt like the victim wasn't valued, and their opinion wasn't valued regarding the plea. The victim filed a complaint against the district attorney for fairness, respect, and dignity, that it was violated. One of the other core victim rights that we have is being informed, present, and heard. And again, you will find that and hear that throughout this entire presentation. Okay. Not all agencies have responsibilities to the Victim Rights Amendment. Some agencies, that notification is automatic. Law enforcement, district attorneys, judges, courts, and the Division of Youth Corrections. All of these agencies are required to provide victims of VRA crimes with notification, and it is automatic, meaning that victim is, as soon as they are labeled a victim, for lack of a better word, they start receiving their victim rights right away. If it's a post-sentencing agency, such as your local jail facilities, probation, community corrections, Department of Corrections or parole, or state hospitals, those victims have to opt in for that notification. So it is not automatic that they receive these services. They have to ask to receive these services. You will notice that nonprofit agencies are not listed on this. They do not have responsibilities to the Victim Rights Act. However, we do consider them watchdogs, and we ask that victims that are working with those nonprofits, if a nonprofit agency hears that a victim's rights are being violated, that they can contact our office or contact the agency that the victim is having problems with and see if they can help resolve that. Okay. Crimes that are covered under the Victim Rights Act. Any crime that is of the nature of domestic violence. So I like to explain that our victim rights crimes are typically person crimes. They're not theft. They're not criminal mischief. However, if that theft is attached with a domestic violence, it becomes a VRA crime. Criminal mischief is not one, but if it's criminal mischief and domestic violence, it becomes a VRA crime. Okay, so anything that is domestic violence. Careless driving causing death, child abuse, crimes against at-risk adults and juveniles. And again, this may be a case where you may see a theft, which again is not a VRA crime. But if it's theft with an at-risk adult, it becomes a VRA crime. Crimes involving child prostitution, bias-motivated crimes, and any criminal attempt, conspiracy, solicitation, and accessory to any of the VRA crimes. Okay. Human trafficking, menacing, retaliation against victim, witness, judge, prosecutor, and juror, stalking, tampering with a victim or witness, failure to stop at an accident resulting in death, and serious bodily injury. You will notice that serious bodily injury is highlighted in yellow. This is because serious bodily injury was just recently added in 2017, and it is added as a new crime to the VRA. Vehicular assault, manslaughter, criminally negligent homicide, vehicular homicide, murder in the first and second degree, assault in the first, second, and third degree, first and second degree kidnapping, first degree burglary, robbery, aggravated robbery of controlled substance. Your sex crimes, so sexual assault, crimes against child prostitution, sexual assault in the first, second, and third degree, unlawful sexual contact, sexual assault on a child, and posting a private image for harassment or pecuniary gain, so your revenge porn, those types of cases. Again, this one is also highlighted in yellow, therefore it is an added crime that was added in 2017. Invasion of privacy for sexual gratification, incest, indecent exposure, violation of a criminal sex assault, and stalking protection order. So we've always had violation of a criminal sexual assault and domestic violence protection order. However, stalking was just recently added in 2017. Sexual assault on a child by one in a position of trust. Sexual assault on a client by a psychotherapist. So what happens if there's co-defendants or a dual arrest and there's a VRA? If the district attorney dismisses the case against the co-defendant because he or she is the true victim in the case and the person should never have been charged, that victim is entitled to the rights under the VRA. So what this means is that law enforcement may go in and they may come to a case, go on scene, and they may not be able to determine at that time that there's a primary aggressor and that both parties may be arrested. Therefore, victim services are not provided to either of them. However, if they get in there and law enforcement can make that determination that one is a true victim, if it makes it to the district attorney's office and their investigator is looking into it and the DA is looking into it and determines that there is a true victim, at that point, then the victim would start receiving services under the VRA and its rights. So we talk about what the definition of a victim is. The first part of the definition for a victim is that a victim is considered a natural person, so it's not a corporation. The victim is a victim and would receive VRA unless the person is accountable for the crime or the crime arising from the same conduct. So I always like to explain this as your typical bar fight where you have two individuals. One of them starts assaulting one person and the other one turns around and starts assaulting the other person. They are both assaulted. They are both arrested for assault charges. They are considered to be a part of the same crime arising from the same conduct. Neither of them would receive Victim Rights Act information and resources. If the person is deceased or incapacitated in any way, then you may have the person's spouse, parent, legal guardian, child, sibling, grandparent, grandchild, or significant other, or other lawful representative to help represent them. For example, of a lawful representative, you could have a GAL, a guardian ad litem, or somebody from Department of Human Services that could help represent that child. If a child is 17 when the crime took place, all that contact information for the Victim Rights Amendment would go to a parent or guardian, or it could be lawful representative. If the child turns 18 during any point of the case, at that point that 18-year-old has the right to receive all their notification directly to them and could choose not to have it continue to go to the legal guardian or the parent. Okay, so what happens When there's notification when the parent is the offender, who do you notify? Who do you contact for this? We always suggest that you look to see if there is another guardian, a family member that would help represent the child, an aunt and uncle, maybe a grandparent that could step in and be a representative for the child. If that's not the case, Department of Human Services, is there a case manager involved in it that they could be the point of contact for you to help represent that child? If a victim has retained an attorney, we suggest that you continue to provide notification to the victim. If there's a consultation that is involved, that you would provide notification to the victim, to the attorney, and then you would also consult with the attorney as well as the victim and both parties. If the victim wants all notification to go to the attorney, does not want you to provide any notification to them, please see if you can get something in writing from that victim to document that they don't want any more information going to them and they want it directly going to the attorney. Include the contact information for the attorney and what type of communication they would like. Would they like it through emails or through phone conversation only? And if possible, if you could get it notarized, that will just help to kind of back your case if the victim ever wants to come back and say they didn't provide me any information, they only provided it to my attorney. So having something documented to show that this is what the victim had requested and they signed off on it. If a victim decides that they don't want any information at all and they would like for you to not contact them regarding their case, because as we talked about before, everything is automatic and we're just going to continue, we're going to provide that to them whether they want it or not. But if a victim says, I don't want anything at all, please don't give me anything, see if you can get them to complete a declination of the VRA services. And what I always suggest is to have something written out that's going to have all of their victim rights listed so that victim knows everything that they are opting out of, and have them sign it so they recognize that, or maybe initial everything that they don't want. And just understand that if a victim chooses to opt out, that they can opt back in at any point in time. So documenting something that they are opting back in and they would like to have those services. Initial critical stages. The filing of charges. These are everything that the district attorney needs to notify the victim on. Anything that you may see in yellow is a right to be heard on. So we have filing of charges, the decision not to file charges, and misdemeanors cases law enforcement is required to notify the victim if there's a decision not to file. The district attorney will notify on felony cases unless there's an MOU in place or something in writing to say that the district attorney's office will provide notification on misdemeanor and felony cases. But the majority of the state, and the way that it is listed in statute, is that law enforcement will provide on misdemeanor and district attorneys will provide on felony cases on no-file decisions. Preliminary hearings, bond reductions, or bond modification. Okay. Now you notice that it doesn't say setting a bond. Setting a bond is not an initial critical stage. Although if there's a bond reduction or a bond modification, that victim has the right to be informed about it and they have a right to be heard. Arraignment, hearing on motions, dispositions, and pleas. Okay. Again, those are items where victim has a right to be heard. Trial, sentencing and resentencing, right to be heard, and a subpoena for records concerning the victim's medical history, mental health, education, or crime victim compensation. The victim has a right to be heard on as well. Victims also have the right to be heard regarding any request by the defendant to modify the no contact order or the mandatory protection order. Okay. Appellate reviews. The right to be heard on modification of sentence or resentencing in 35A and 35B cases. The decision to conduct the DNA testing, the results of the testing, and the court proceedings initiated based on the results. Attack on judgment or conviction. Petition by sex offender to cease registration. And any hearing concerning a petition for expungement of juvenile records. That victim also has the right to be heard on. So there's been some confusion on the modification of sentence. So this is just to help explain that a little bit further. The DA's office shall inform the victim of sentence modifying hearings of 35A or 35B. It was at one point talked about that it should have been probation's responsibility, but it is the district attorney's office. Okay. However, the probation department will inform registered victims, because they have to opt in for their notification, of resentencing following a revocation hearing and early termination hearings. Those are no longer the responsibility of the district attorney's office. It is the responsibility of the probation department. So the right to be heard when unavailable. If a victim is unavailable to be heard in court, maybe that's for safety reasons, maybe they can't financially make it to the court, maybe they just don't feel comfortable being in that courtroom and they can't make it. If a victim is in jail, that is another reason why they can't be present in court, but it is their right to be there. They do have the right to be heard, though. So what we are suggesting is that the district attorney work with that victim to see if they can arrange some form of phone or similar technology to have that victim present. Sometimes what this has looked like is we have our victim advocates who have a calling card, who are able to reach out to that victim and call the victim and let them know that the court hearing is starting. They can be present to hear it through the phone, and they can speak when it is their turn to speak. It's right to be informed of the available resources of travel, childcare, financial assistance, transportation and interpretation, following up support, counseling referrals, and assistance with creditors and employers. So when we talk about interpretation services, if a victim needs a translator, it's best that we know this, that as the district attorney's office, you know this ahead of time so that you can have those services available to the victim either through a language line or a person who is present in the courtroom with that victim so that they can be aware of what's going on in the court and they can understand and participate in that court process. Okay, victims have the right to be informed of the status of the case and to be advised of any scheduling changes if known in advance. We always ask that you provide that information to the victim with as much time as possible so that they can make an appearance in court. They have the time to arrange their schedules with work, with child care, so that they can be present. So as much notice as possible for that victim to attend court would be beneficial. Reasonable attempts should be made to protect the victim from harm, harassment, intimidation, or retaliation, and providing information regarding protective services. So what this could look like is if a defendant is harassing a victim, what steps can they take to protect themselves? Getting a protection order, maybe modifying the protection order. It could also be if new charges need to be filed, how to get them in touch with the sheriff's office or the police department so that they could file new charges of harassment. A victim may be present at all critical stages unless the court or the DA determines that exclusion is necessary to protect the defendant's right to a fair trial. So with that, we talk about sequestration versus the right to be present. Sequestration is a rule of evidence, while the right to be present is a constitutional right. One thing to consider when determining if a victim should be sequestered from the court hearing is the victim's presence affecting the defendant's right to a fair trial. One court case to take a look at is Colorado Courts of Appeals case, People v. Coney. This will go into a little bit of detail as to the victim's rights and how a victim was sequestered from a case that really shouldn't have been, and it had no impact on how the defendant would have if they would have gotten a fair trial or not. A pretrial motion can be used to determine whether the court will allow the victim to remain in the courtroom. And just in 2017, a couple more things were added to the VRA regarding sequestration. The right to be informed by the DA of the motion to sequester the victim from the critical stage, and the right to have the court consider the victim's position on the motion to sequester. With this, the court shall state in writing or on the record that the victims object to this and state why they object to it. The judge needs to on the record or in writing, explain why the victim would be sequestered and how it could impact the trial and defendant's right to a fair trial. The victim has the right to a secure waiting area, the right to be assured that officials will take action to achieve a swift and fair resolution, and the right to be informed of any motion that will substantially delay the prosecution. The DA shall inform the court of the victim's position on such motion. The right to be informed on protection orders, and if that protection order is modified, how to modify the protection order if the victim would like to modify it. To make reasonable efforts to redact any of the victim's Social Security information from reports before they are made public, and the right to be informed of the results of the court-ordered HIV testing. Quick setovers. So what happens if we're sitting in court and the judge wants to continue the case until tomorrow, and it is a critical stage where the victim has the right to be present, they have the right to be heard at. One suggestion is to have the DDA make it a point on record to say that the victim would probably like to be present, or you need to at least reach out to the victim to see if they would like to be present for that hearing, and you don't think that 24 hours is enough time to get that victim there. Okay? Make a record of it. If the judge decides to go ahead and proceed and schedule it for the next day, do a good effort of try to get a hold of that victim. And if the victim can't be present and the victim wants to file a complaint, it would be on the courts and not the district attorney's office, because the DDA made a point of making a record of it that wasn't long enough and asked for an extension. There's been a couple of times where judges have requested that DAs contact the victim right after court and ask them to be present. Sometimes they will have a recess and have the DA try and reach the victim. Even if they can't get a hold of them, still make a record that they attempted to contact them, and if the court sets it over, then again the DDA is covered. The right to consultation. The victim has the right to a consultation with the district attorney regarding their case. We suggest that the district attorney have a full and frank discussion with the victim regarding any explanation of the initial criminal charges, if there is any changes to those criminal charges, if there's going to be lesser charges, any sentencing considerations or changes to the sentencing. If the district attorney meets with the victim and has these conversations with them, and then the plea changes, there needs to be another consultation, and the victim has the right to be part of a second consultation, and back and forth right up until the point of sentencing. It is always best to put all of the possible outcomes out front for the victim to be aware of, so when they are in court, they are not surprised of anything that is happening or anything that you're requesting. They are fully aware of it prior to going into that courtroom. Okay, subpoena for victims' records. At a proceeding specific to Section 24-4.1-302.5(1)(d)(7) involving a subpoena for records of victim, the court shall ascertain whether the victim received notice from the district attorney's office of the subpoena. After considering all the evidence relevant to the subpoena, the court shall deny a request for a victim's records that are privileged unless the court makes a finding supported by the facts that a victim express or implicitly waives the victim's statutory privilege specific to Section 13-90-107. Privacy issues. The right to prevent any party at any court proceeding from compelling testimony regarding the current address, telephone number, or place of employment for the victim. The victim has the right to be notified of how to request protection of their address. And the district attorney shall inform the victim of the following: the availability of the district attorney to seek a court order to protect a victim's residence address. Victims have the right, at the discretion of the DA, to view the pre-sentence investigation report. I know a lot of district attorney's offices do not allow victims to have a copy of that. They may allow that the victim can come in and view the pre-sentence investigation in their office. They may allow them to review a portion of it, or maybe just deny them all access to review it altogether. Victims have the right to have the court determine restitution, the right to receive information as to how to opt in for notification for post-sentencing agencies. Because as we talked about before, is those victims, that notification is no longer automatic. They have to opt into that. So the district attorney is required to contact the victim and let them know where they're going to be going as far as post-sentencing, whether that's probation, community corrections, jail, Department of Corrections, and how to opt into those services. Victims have the right to be informed of the availability of restorative justice practices and what's available within their community. Okay. Sealing of records. This is something that is new in 2017 as well. Prior to 2007, September of 2017, the way it used to be is that if a defense wanted to file a motion for sealing of records due to a case where the defendant was acquitted, or if they were acquitted, excuse me, then what they would do is the defense team would file a motion with the courts, and the judge would look at the paper motion, sign off of it, and move on. Right? What has happened now is that we have changed our statutes and our laws to say that victims have the right to be notified of this. So if there's a sealing of a record and there is a motion by it, that the courts have to contact the district attorney, who then will have to contact the victim to let them know that there is a motion to seal the records. And within 42 days, that victim has the right to be aware of it, and a hearing would be set. The victim does not have a right to be heard at that hearing, but they have a right to be notified of the hearing. This allows the victim time to get police reports or any other information they would need prior to the case being sealed. Okay. The courts have responsibilities as well to inquire if the victim is present and wishes to be heard at critical stages, to determine the amount of restitution, notify victims when offender petitions to cease sex offender registration. Now, we also saw that with the district attorney's office, to notify the victim on ceasing sex offender registration. The reason that it is added to both is because if there is a petition to cease registration, it is going to go to the court. Then the court would contact the district attorney's office, who in then return would contact the victim. The district attorney's office is the one that would have the victim's contact information, so that is why they are involved in it, and they would reach out to the victim. And then make any reasonable efforts to accommodate the victim upon the return of a verdict by the jury. So if a verdict is reached, then the judge needs to make sure that the victim is present and is there to hear the verdict instead of proceeding. So we get two different types of Victim Rights Act complaints. We have informal complaints, which most of the time victims will reach out to our office and they may ask for assistance in a case. They may ask for anything of, I'm trying to get a hold of the district attorney on my case. I can't reach anybody from their office. I've left numerous messages and nobody will return my call. So what I may do at that time is reach out to the victim advocate with the district attorney's office and let them know that the victim has been trying to reach them. Maybe it's because the district attorney's office does not have a recent contact information for the victim. Maybe the victim's voicemail is too full and they can't leave a voicemail if they've tried to call back the victim and they just can't seem to connect. So I'm going to try and facilitate that to help them reach so they can communicate as well. We'd like to try and reach a local resolution before it gets to the point of a formal complaint. That doesn't always happen, and victims often want to file a formal complaint, and they can do so if they please. They have to contact our office in order to get that, the form and the packet to complete the formal complaint. If a formal complaint is filed, it will be heard by our VRA subcommittee, which includes a judge, a chief district attorney, a DA victim witness coordinator, a chief of police or sheriff, a victim of major crime, a rural representative from a DV or sex assault agency, and a community representative. As you can see, it's a very well-rounded group of individuals with a wealth of knowledge about the criminal justice system to make an unbiased decision and help understand where victims are coming from, as well as work with agencies on helping to ensure that this doesn't happen again in the future, which is what our goals are for filing a VRA complaint. We want to make sure that there's a resolution that's been met. We want to prevent future violations. We want to make sure that if there is a violation, that this doesn't happen again to another victim. And we want to make sure that there's system improvement. What can we do to make this better? Some of the ways we work on doing that is that our VRA subcommittee may require that training be held, whether that's a Victim Rights Act training, a victim empathy training. One of the bigger ones that we often see is policy change, or maybe updating a policy. Maybe there's new changes to the statute that didn't get added in their policies of how they're going to work with victims, and how they're going to make sure that they are provided their Victim Rights Act and there is not a violation. And then maybe meeting with the victim if that's something that the victim would like, or an apology letter to that victim. what our complaint process is, it's not a do-over process. So a victim is hoping that their case will be held again, or they could go back to court and have the hearing again. We can't do that. We can't make the DA's office file a new case. We can't ask them to file charges or different charges, or make law enforcement arrest someone. We can't make probation departments revoke someone or change the outcome of the case. Again, our process is for system change and hoping that by this violation, it'll encourage that agency so that they do not do this again to fix what was wrong. So some of the complaints that we have gotten with the district attorney's office is treating the victim with fairness, respect, and dignity. And as you remember when I started this, we talked about this as our number one complaint across the board for all agencies. Consultation, making sure that there's a consultation with the victim. If there's a change in the plea, making sure that they go back and address that victim again and let them know what the change is. So every time it's changing, make sure we're following up with the victim to have that conversation. Now, the victim may not always like the plea, and that's okay. They may not agree with what you're going to present to the court, but they need to know about it ahead of time. Okay. Not be informed of the right to be heard, the right to make a written victim impact statement and or oral statement at sentencing, informed of the availability of financial assistance and community services, informing victims of decisions not to file charges, informing victims of subpoenas for protected information, and notification to victims of critical stages in the criminal justice process. So when we look past the last 10 years of complaints that our office has received, you will see in 2017, as well as the past 10 years really, is that the district attorneys and law enforcement have the bulk of the complaints. Now that's not necessarily because they are doing a poor job. It's just because they have the bulk of the VRA. So everything that they are being provided to victims is automatic. So they have more of a responsibility to the VRA than your post-sentencing agencies, which is why there's lesser complaints that are coming from post-sentencing agencies. So how can we commit to assisting victims? Taking time to listen to them, find out answers if we don't know them, and returning that phone call to the victim. If a victim is calling and leaving messages and nobody will return their phone call, and if we reach out to you to say the victim hasn't heard anything from you and your response is, well, I don't have an update on the case, so I haven't called them back. Okay, we can see that that might be a violation because it's a pattern of unresponsiveness which would fall under fairness, respect, and dignity. So reaching out to the victim, even to have a conversation with them to say, I recognize that you've called. I don't have an update on the status of your case, but as soon as I do, I will be in touch with you. Okay, following up with that victim. Making referrals is necessary. If you don't have a resource for the victim and they're asking for assistance, send them, give them the information for another referral, or reach out to another agency and provide that victim's contact information to that agency if the victim is okay with that, for them to reach out to the victim so that the victim doesn't have to do the runaround. Have empathy and attempt to understand their frustration. Victims didn't ask to be put into the system. They were put here not on their own free will. They don't understand the judicial system. It's very confusing to them. So understanding that they're dealing with their own trauma and their own frustrations, and it's not something that they have to deal with every day like we do. And take care of yourself. There's a lot that happens in our lives and a lot of cases that we all see that are very traumatic to us. So making sure that we're taking care of ourselves so we can help others. My other suggestion is to ensure that you're documenting everything. So if there's a conversation and a consultation with the victim, to make sure that you're documenting that consultation and what was said in the consultation, what the parameters were, what you were offering, what the offer changed to, anything like that. Because going into your documentation and just saying, met with victim, consulted about plea, okay, that doesn't explain to us what the consult was, what was said in that consultation. So that could be a violation. So make sure that you're documenting everything. Okay. Here's my contact information. If you have any questions or concerns regarding the Victim Rights Amendment or a case that you're working on that you would like some assistance with, please feel free to reach out to me either by phone or by email. Thank you for joining me today.